This is video 1, weeks 6 to 7 for the introductory course. And what we're looking at in this screenshot video and in this 2-week period essentially is what I call the model of judicial decision making. And we're going to eventually be looking at 3 different decisions of the United States Supreme Court to illustrate the model. When I'm going to the last screenshot video I did, which was the sources of legal authority, and I'm going to page 7, and I want to review the material there regarding the model of judicial decision making. And I don't know if we're going to end up with 1 or 2 videos here, but I don't want to hurry this. So when I talk about the model of judicial decision making, what I'm talking about is how do judges make decisions about questions of law. In every lawsuit, we're going to have questions of fact, right? How fast was the car being driven? What was the extent of the injured person's injuries? Question of fact, did the defendant intend to kill someone? Question of fact, was the defendant aware that what he had in his possession was some kind of stolen property? Those are all factual questions. And the way our system works is that if there's a jury, the jury decides the factual questions. And if there's not a jury, sometimes there won't be, then the judge decides the factual questions. But there's also going to be legal questions that arise in every lawsuit, because you can't have a lawsuit without, number one, a rule of law permitting the plaintiff to recover if it's a civil lawsuit, or a rule of law that says that if the defendant did something, it's a crime. Not only do we have those sort of ultimate legal questions, but we also have, let me get back, if you're in the crimes course with me, an ultimate legal question would have been, in the Robert Strong case, did the defendant commit reckless homicide, or did he commit criminally negligent homicide? We also have in any lawsuit, if there's a trial, all kinds of other legal questions in terms of the admissibility of evidence, procedural disputes. Remember, Robert Strong ultimately was decided on a procedural dispute that the highest court in New York said that the trial court judge improperly didn't charge down and give the jury a choice in verdicts. But whatever kind of lawsuit we have, again, if there's a legal question, how do the judges decide the legal question? And this is where we bump into this, what I call model of judicial decision making. And the reason I'm spending the time I am with this, first of all, is a practical matter. I think this is going to be useful to supplement what you're learning, or will be learning, what you'll be doing in the legal research and writing course. But I want to also point out that if you're an attorney or a paralegal and you're working in the area of litigation, meaning you're representing or assisting a lawyer who is representing a person in a lawsuit, questions of law are going to be popping up all of the time. And so we know that those questions will be decided by a judge, but the lawyer's job and the paralegal's job in assisting the lawyer is to try to persuade the judge to answer the question in a way that favors the client, or if that can't be done, to devise a strategy that will help the client navigate through that situation. But we've got to know how the judge is going to go about making or coming up with an answer about a question of law. And I understand that some of the time there's not much of a question because the answer is going to be so obvious. But if the answer is that obvious, my guess is the question doesn't pop up. When the question does pop up, what I'm going to tell you is that the judge is going to see, no matter where the question emerges from, it could be a question under a statute, it could be a question under the Constitution, as we'll be looking at later, it could be a question arising from an administrative regulation, and so on. The judge is going to be looking at precedent. In other words, the judge is going to ask this question: is there a past judicial decision that has decided the same or essentially the same question of law that I'm now faced with? This is, if you remember, how the common law started, but today it's become the model of judicial decision making. I can remember in my first job out of law school working for a judge, and this was back, of course, before there were computers and digital sources of information, and I would spend a good part of my day researching judicial decisions relating to questions of law that the judge had to answer. And what we would want to remember is not only this concept of precedent, but that we have a layered judicial system. Easy for you to say. Meaning we got higher courts and we've got lower courts. So the model of judicial decision making is really how are judges going to view precedent on a legal question that they're trying to answer. And here we have three different rules. If the precedent is from a higher court, it must be followed, which makes the United States Supreme Court such an awesome court in terms of power. Notice I linked awesome with power. So whatever the Supreme Court decides has to be followed, if you will, on that legal question by all of the other courts in the country, because the Supreme Court is the highest court in the U.S. On the other hand, if the precedent is from a lower court or a court from another jurisdiction, it does not have to be followed but can be considered persuasive. And I think I have it in there somewhere, but without trying to dig it out right now, I knew I had a case in New York once. The precedent we found was from Minnesota. It was really solid in terms of supporting our client's position. There was no precedent from the state of New York. It was a question of New York law. And I remember the judge saying to me at oral argument, I'm aware of the Minnesota case you've cited, meaning brought to his attention, but you know I don't have to follow it. And of course I said, I appreciate that. And I added, but Your Honor, I believe the reasoning is such that respectfully it should persuade you. And that's what we mean by the second rule. The third rule may be something, if you follow the United States Supreme Court, by way of example, is going to be very interesting in the near future, meaning the next 3 or 4 years. If precedent is from the same court, it should be followed. It should be followed unless there's a compelling reason not to follow it. And of course, this is where we come up with the concept of overruling precedent. But I'll now shift to those 3 Supreme Court decisions, and we can view this these 3 rules in the context of those 3 decisions. And let me just end this video, because I want to do a separate video on the Supreme Court decisions I just decided. The third rule of precedent here, where I said if you follow the Supreme Court, the composition of the Supreme Court has significantly changed in the last 4+ years due to the fact that there were vacancies on the court. And as always is the case, the president gets to nominate someone, and so then it's up to the Senate. If it's given to the Senate to pass on it, you'll remember that the Senate wasn't able to pass on the last Obama nominee. But in any event, the last president, Trump, had three different appointments to the Supreme Court. Scalia died. Obama couldn't get his guy in there. And then Trump, when he became president, and that was appropriate. I mean, there was still a vacancy, and he appointed, I believe it was Justice Gorsuch to take that place, to take that slot, and then Justice Kennedy retired, and the president at the time, Trump, appointed Kavanaugh to take his place. And then last fall, in what turned out to be the last few months of the Trump presidency, Ruth Bader Ginsburg passed away. That was the third vacancy, and the president appointed a woman, Amy Barrett, to the Supreme Court. But the composition of the Supreme Court has become more conservative, to use that term, and to get to Rule 3, there's a question whether or not the Supreme Court, with this solidly conservative background, will be deciding to overrule or not overrule Roe versus Wade. But we'll talk about Supreme Court decisions in the context of apartheid in the next video.